Hello, Sanbonani Babugeli, and welcome to this week's exciting edition of your favorite program, Yilungelo, Lakho. It's your right. We're coming to you live here on SABC 1 Mzansi for sure, as well as SABC Plus. Uma wena you went and actually downloaded the app, uhleli noMadngolosi uAlisha uNhlanhla wakajali Mbukeli. Cabanga ke ukuthi ungumuntu phela uqashile, ukhokha irent inyanga nenyanga, kodwa uzithole phela wena usucishelwa amanzi nogesi ngendaba yokuthi uma stende wakho akazange yena ukhokhela umasipala. So udouble team lo asilifakela ama specs lolu daba. Rental accommodation arrangements Mbukeli between tenants and non-compliant landlords can actually place those tenants in a very difficult and sticky situation when they actually fail to adhere to community schemes' financial obligations. Ngoba kwenziwa njani ke Mbukeli phela ngomastandi ongalandeli imithetho yama-body corporate noma bengazikhokheli izidingo zomasipala bashiye labo abaqashile phela bese inkingeni. For this discussion, we're very pleased to have three gentlemen in studio with us this afternoon. Let's welcome attorney, I'm sure you remember him, Mr. Ellen Levy there, Sinayo Futino advocate Emmanuel Masomboka Omele Rental Housing Tribunal. We also do have Mr. Keith Bateman from the Bluegrass Community Scheme Managers. Gentlemen, a very good afternoon to each and every one of you. Welcome to the show. Let's start with you, Keith. Hello.
Thank you.
How are you doing this afternoon? Tell us a bit about what it is that you do at Bluegrass Community Schemes.
So we manage complexes, sectional title and homeowners associations across the northern and western parts of Johannesburg.
Thank you. All right. Advocate Emmanuel, sakwamukela nsizwa ohlelweni siyazi housing rental tribunal yenzani kodwa ukhumbuza ababukeli emakhaya ukuthi nenzani umsebenzi wenu.
Yeah, so mama, rental housing tribunal iresolve inkinga between abo mastand nabaqashi. So if unenkinga either umastand or either umqashi, you can come to us, we can resolve any issue that we have. We are constituted in terms of Rental Housing Act. Yesiphamanga ukuthi sikhona ukuxazulula zonke inkinga pha kwa mastand nabaqashi.
All right. So Alan, I mean, I think the last time we spoke, it was issues because tenants could not pay their rentals due to the fact that they were either losing jobs or shifts were getting smaller due to the COVID pandemic. So there's a new phenomenon now where landlords are actually not paying municipal rates. So tell us, what would you then advise a tenant who now has had their water switched off or any services, basic services like your water as well as electricity, because the landlord did not actually pay the municipality, whereas I, as a tenant, I've settled my rent and on time?
Probably to leave the property immediately or sign up a gym contract so they can take a shower. Jokes aside, this is happening very often. There's a multitude, if not tens of thousands, hundreds of thousands of properties around the country. A large portion of them are situated in community schemes. And we know that community scheme owners have an obligation to pay the local municipality for rates and taxes, but they also have an obligation to pay the body corporate or the homeowners association for levies. And yes, we do have tough economic times, and a lot of these owners can't afford to pay the body corporates the money, or they spend their money on other items and they fall into arrears with the body corporate. And that can often lead to, number one, the flat they're living in being sold, sometimes without them even knowing, as a tenant or as an owner, and also to the utilities, the electricity to the flat or the water to the flat being cut off or limited.
And then, advocate, can I ngingenza njani lapho if ngithola ukuthi nginenkinga whereby mina ngikhokhile rent yami but umastanda akazange asettlishe ilokhuzana umasipala, kwenziwa njani lapho sengithola sengivalelwa amanzi mina nogesi?
So ordinarily the first thing also yenza mama, you come to Tina a tribunal.
Okay.
Yeah,
this is after I've exhausted wonke ingxoxo nayo landlord ukuthi why is my water not running?
Yes,
why am I not
yes,
having
yes,
access to electricity?
Yes, no, of course. Because your first port of call you approach the tribunal. Mawune inkinga because ngokomthetho landlord must not cut electricity no water yakho off without a court order, or must also ensure in terms of rental housing act read together with a unfair practice regulation, even with a contract that the parties concluded, to provide you with undisturbed water and electricity. No matter ngasho ukuthi uyakolota phezu kwamanzi ku-rent no-electricity, landlord must stand akanavumo ukuthi acimele amanzi or acimele ugesi without a court order.
Okay. Yeah. And then, Keith, I mean, I'm trying to establish here, like, what rights do tenants have, particularly when the landlord is the one that has not been servicing the municipal debt, and then I'm stuck without water as well as electricity in my house, yet I've paid rent in full and on time?
So first of all, the tenant should expect to have those things in terms of the agreement, and his rights or her rights should never be affected without some sort of court order. And as far as a body corporate is concerned, a responsible managing agent would never go and cut off water, electricity without such an order. That's just plainly illegal.
Okay. All right, so you're basically saying that the state management or the body corporate where state does not have the right to come and switch off my services purely because the landlord has not settled their debt. Am I understanding this correctly?
Yes, except in the case where there's been an order granted, in which case there would be notice at very least to the owner. And there's most of these things are heard in the High Court. It's more Alan's side of the equation, but these go to the High Court. And courts generally don't grant orders without the people who they're ordering against having had their say.
So, Alan, what would then be the order, like the processing order? Who has to notify who before that water or electricity is actually shut off? Is it the body corporate in my state notifying me, or they actually notify the owner if I'm a tenant in this place?
So, unfortunately, the body corporate or homeowners association bring the application to the court.
Okay.
It's normally
against the owner of the
owner,
premises.
Yes.
Okay.
He's called upon to appear in court. In most cases, the owner's in arrears. He either doesn't know the application's being heard in the court, or he doesn't know the importance of attending at court, or he can't afford an attorney. So in the majority of these cases, they're heard unopposed by the relevant high court, and the judge gives an order limiting the water and cutting off the electricity. And that would be served by the sheriff of the court roughly 15 days after the order's given. So as soon as 2 or 3 weeks after the order, the tenant can find themselves without electricity and with their water limited to, for example, 6,000 litres a month is the going amount.
Okay.
And unfortunately, the High Court rules, so to speak, or the procedure, or the judges who hear these applications actually don't insist that notice of the application is served on the tenant.
Yes.
I know when my office brings these applications for community schemes, we do not serve on the tenant because we actually don't have the tenant's name. But we could still cite the tenant on the court papers as the tenant and at least serve a copy of the application. But we don't. So what's actually in practice happening throughout the country is the people most affected by the order, the ones that will find themselves with no power and limited water, aren't receiving notice of the matter coming to court.
And advocate, how prevalent is this behavior where uthola ukuthi mhlawumbe umastand uyazi ukuthi unamacala ne akakhokhile, but wena as a tenant you are the last person to know, uzobona ngoba amanzi esecinyiwe nogesi?
It's actually quite prevalent, Mama. We deal with quite a lot of those cases on a daily basis. And ordinarily, Tina, our approach yet is because we can't issue out the order against a
tenant.
No, against the body corporate.
Okay.
We can only issue out a ruling against a landlord.
Okay.
Must stand. We can only tell who must stand comply with your obligations, make sure, take steps to ensure that water and electricity is restored. Yes.
Okay. And Keith, how does one then get to lodge a complaint with you guys? When does it, are you the first point of call, particularly when you find out that your services have been switched off, your landlord is not talking to you, then you're trying to find out what's going on in your unit?
Yeah, so I think it's important that we see that we would be acting in terms of an agreement with the body corporate. So that's our client as a managing agent. So we very much would be looking after the body corporate's interests, not necessarily the tenant.
The tenant,
So
yes.
I just want to pick up on something that Alan spoke about. The sectional title segment of the market is the one where most often these applications come, because homeowners associations, typically the units are directly owned. There's not all these common property costs, so the levies aren't that big. But there's an interesting prescribed rule that actually says that the body corporate must have a list of all the tenants, names, addresses, and typically there's intercoms and things like that. So most body corporates and most managing agents do actually know who the tenants are.
Exactly.
So it's something that should be explored,
Yes.
and that information should be available to the attorney when they are going there. So I think this has touched on something quite important.
Very
as
important
far as,
indeed.
the homeowners' rights and the tenants' rights are concerned.
Alan, you're going to explain this further after the break, though. Mbukeli, let's take our first quick ad break. After that, I will be opening those lines. Usishayele ucingo, usitshele ukuthi wena inkinga yakho mhlambe between wena nomastande noma wena we-owner yale ndlu kodwa awusakhona ukukhokha ama-services. Ithini i-body corporate ivane yakucimela amanzi? Yiziphi izindaba abathi baza nazo, or other ways abayi-explorayo ukuthi bazame ukuthi bakusize? Ilungelo lakho, we're back shortly after this. Don't go anywhere. Mbukeli, welcome back. You're watching Yilungelo Lakho live here on SABC 1 as well as SABC Plus. Namhlanje ke Mbukeli sikhuluma ngayo yonke into emayelana ne-landlord, ne-rent, nama-services, namanzi acinywayo nogesi ocinywayo. Ungasifonela ke e-studio. My lines are open 011-714-0671, alternatively 714-0672. You can send us a WhatsApp on 060-844-9857. Alternatively, send us an email to consumer@sabc.co.za. My guest today, Advocate Emmanuel Masomboga ovela a rental housing tribunal, alongside Mr. Keith Bateman from the Bluegrass Community Scheme Managers, as well as attorney Mr. Ellen Levy. So, Ellen, you are about to explain something that was a quagmire for myself as well as Keith. Please go ahead.
Thank you. Tying up to what Keith was mentioning before the break, every body corporate in the whole of the country is obligated now to keep a list of all the tenants in the complex. We're talking about hundreds of thousands of tenants, and the body corporate has to have each tenant's full name, each tenant's email address, and each tenant's phone number. And this will make it very easy for any attorneys acting for the body corporate around the country when suing any owners for recovery of arrear levies. The attorney can quite easily get the tenant's contact details. And we were speaking during the break with my colleagues, and we were saying that definitely going forward, the courts have to give a side to the tenant when it comes to the applications that the court is hearing to cut off electricity.
Absolutely.
It's not good enough for the courts to give that order unless the person actually affected by the order, who will be without electricity, has been notified. And as we say, it's quite easy for the attorney to get the tenant's details. If you're not going to serve the tenant by way of sheriff of the court, who normally serves these court applications, email the tenant, phone the tenant, let him know what's coming. And as I say, the judges granting these applications should be insisting that the people who are affected, the tenants, get proper notification.
Because, Keith, I'm trying to understand, say, for example, in that example that I made for you while we're off air, where you have a situation where the body corporate is actually switching off services to the tenant's premises, and the tenant is unaware of what all these services that haven't been paid actually are. So what is the right then of the tenant? Because I can't then move from that house because I've paid my rent in full, as far as I know.
Yeah. So the tenant definitely, I would say, needs to go to the
housing tribunal.
Housing tribunal. It probably would have a right.
But what would have happened, Kid? Sorry to just cut you off there. What would have happened? Would you not have had enough communication with the landlord in that you're taking drastic measures now where you basically have to go and switch off services in the unit without even knowing whether there's a tenant or not that is currently residing in the premises?
Yeah, so I think what sometimes does happen, it's actually the landlord himself or herself that does these things.
Yeah.
So the body corporate wouldn't know, the managing agent wouldn't know. We would be as surprised as the tenant to find out that this has happened.
Yeah.
Because remember, the owner, the landlord, would have access to the complex, could come and do his thing.
Absolutely.
So that's the surprise. One must also sometimes be careful that there are cases where the municipality is not paid for water, electricity
by the estate,
by the body corporate,
by the
estate.
Yes.
And that sometimes is a consequence of owners not paying their levies. And then, Joburg, we're in Joburg, they just arrive and they say, here we are, here's our paper, and that's it. So very little notice, and then everybody's just going to run around quite hastily to make something happen.
But surely, advocates, akukho emthethweni lokhu, because abantu abasafarishayo ilaba abangenacala, of which they're actually ibona abakhokhayo and are up to date. Are there ways then that as a tenant ohleli endlini can then maybe find out from the body corporate, let's say you don't have a great relationship with your landlord, which you should, then ukhulume nelokhuzana ne-body corporate and just find out what are some of the arrears at my unit? Are you able to ask for that information as a tenant so that you are always kept abreast in terms of what's going on in your premises?
Look, insofar as we are concerned, between tenant and landlord, they're governed by lease agreement.
Yes.
And lease agreement basically preserves the sanctity between the parties there.
Yeah.
So if I'm a tenant, I should not be looking outside of what the agreement tells us.
Yes, of my landlord.
Yes, for Melanie said. It's, for example, if umastand ufuna imali yakhe, akusinkinga kamastand ukuthi angikholanga le nyanga. I must get my money. You understand? So any rights that a tenant and or a landlord can exercise needs to be within the lease agreement, read together with a Rental Housing Act, together with the unfair practice regulations, because that in law would actually give you a right to exercise any entitlement in law to protect ama rights work. In terms of the law, we have this concept ababiza ukuthi cause of action. So cause of action basically is your modus operandi, your vehicle in terms of exercising amalungelo wako, and within the tenant and landlord relationship, it's clearly defined. Qala i-Rental Housing Act, bese kuza ama-regulations wakhona, bese i-Consumer Protection Act,
yes,
bese kuza ne-lease agreement.
All right.
Okay. And exactly within that hierarchy. So it would be difficult for a tenant to go to the body corporate and request that information, because it's easy for a body corporate to well say, but what is your legal right in terms of that? Unless if, there is a provision within the scheme of CSOS and those laws which would entitle that. But I must have a legal right to certain information, and if I'm not entitled to within the scheme of the laws which govern a relationship here between landlord and tenant, then the body corporate has a right to say, look, you're not entitled to this information, it's got nothing to do with you.
Okay.
It's tantamount to example, uthi umastand uye company yakho ufika la uthi okay fine, tenant ithi ayikholanga this month.
Yes.
Tenant hasn't received a salary. Is that true or not?
And they're not right.
That doesn't have that right. So that's the simplest example to make. And that's why the best form is to approach a rental housing tribunal, because a rental housing tribunal will guide you in terms of what your rights are. Because we do accept, we call them a case law, a backroom case where a police agreement, it's an oral agreement. Even if we ngomlomo kwa manje, is illegal.
I like that you're going le route engfuna siye ngayo advocates yama backrooms because nabo phela labo bantu they are deemed as almost and we're going to take another quick ad break. Remember the lines are fully open. Ungasfonela usithinte lapha on our social media platforms. We are going to be back shortly after this. Don't go anywhere. Back is Izindaba zivuliwe 011-714-0671, alternatively 714-0672. You can WhatsApp us 060-844-9857. Alternatively, interact with us on our social media platforms. So, Advocate, a very interesting point obuyikhuluma la because sikhuluma nendle emnyama kakhulu la abantu abaningi kungasayinwa ilease njengoba uwenza a perfect example yalabantu abaqashe kuma backroom. Uthola ukuthi kuba ne dispute because uma stand usefikile wacima ugesi or wacima amanzi because akhokhiwe or naye uma stand itself akana ugesi because akazange azakhokhela umasipala. We resolve kanjani? Is this a case for rental housing tribunal? Can those people bring ilokhuzana indaba enjalo to you guys to try and resolve?
Yes, amalungelo wabo afana nalamalungelo abantu abanamalis.
Okay, even if it was a verbal agreement, a gentleman's agreement, sashake izandla kuyafana.
Yes,
umthetho uyayirecognize.
Isivumelano.
Okay.
Asibe kanjalo.
Okay.
Ne. Masithi isivumelano in terms of the realm of rental housing, we call it, or tenant and landlord, we call it lease. Ne. Lease just defines a type of isivumelwano. Isivumelwano can be oral, it can be in writing. Umthetho wase South Africa recognizes ukuthi isivumelano somlomo isivumelano sangamampela, you know. So amalungelo wakho, ne, you can exercise them exactly the same way as the same person or on a contract in writing. So what would usually happen if kunokuphikiswana ukuthi no asinaso isivumelano thina as a tribunal we do have arbitration where we firstly ascertain ukuthi was there a lease agreement isivumelano ngabe sikhona na.
Okay,
yabona, and isivumelano mangabe sikhona, then what do we look at? We apply the rights and obligations in terms of the Rental Housing Act.
Okay,
and then we just move from there.
Okay,
yeah.
All right. So, Keith, let's move on from that now that we understand the order as well as process of engagement. So, in terms of levies, now, people want to understand how are they calculated? Is it the body corporate that decides how much the amount of levies is going to be incorporated into whether if you're paying back, of course, if you're either renting, that's between the landlord and the tenant, or if you're the owner, meaning it's coming directly from what you pay back to the bank?
Yeah. So I think the important word is body corporate.
Yes.
So that means it's all the owners who own in the scheme. They collectively are the body corporate.
Okay, and they decide on the amount of levies per month.
Yes, so once a year there's a meeting, there's a budget. There's actually two budgets in sectional title, one for the long-term costs and one for the running costs. And owners decide what the total levy is going to be. They approve it. It's a very specific thing on the agenda.
What is it based on? How do you...
On the operational costs.
Okay.
So you do the security, all those things that need to happen. And then in sectional title, the long-term fixing up of the complex, the repainting, all those things go into the 10-year maintenance plan. And those then come to the meeting, and people say, right, this is what we need to pay, and that's how it's determined. So and owners have the right to be there. Unfortunately,
not all of them are always present.
The majority don't come. We battle to get a third of the people there, which is what the law says we must do.
It's like the school governing bodies.
Come in at this point,
yes,
again, guess what the legislation says about the meetings? Are tenants invited to the meetings?
No.
No. Again, they're left out of the equation.
Yes.
Perhaps the most important people in the equation aren't in the equation. And really, one would hope for an amendment to the sectional title legislation to at least give notice to tenants to attend these meetings. And touching on what we said a few minutes ago, one would hope that judges in the high courts in the future insist before cutting off utilities that tenants are notified. Because as the advocate touched on, the most important document to a tenant is his lease agreement and is the Rental Housing Act. But actually the most important thing a tenant can have is common sense. Please, for the tenants out there who are listening, for those of you who are about to sign lease agreements, do not put pen to paper until you've seen the financials of the body corporate. Make sure you're renting in a community scheme that has a good set of financials, who don't have excessive debts, who have a reputable managing agent.
How do I find that out, Alan? Do I just go to Keith's office and be like, Keith, please furnish me with this information before I sign my lease?
You probably could have done that 3 years ago, but unfortunately we have a new piece of legislation called the POPI Act, the Protection of Personal Information Act. And unfortunately, Keith will not be able to give that to you as a tenant, but he will be able to give that to you as an owner. So tenants out there, before you put pen to paper, tell your landlord, I'm ready to sign my lease, but please request the body corporate or the managing agent for the financials of the complex. Please give me a copy of your actual levy statement. Mr. Landlord, before I sign the lease with you, I want to see that you're up to date. I want to see that this complex is in good financial standing.
Oh no, they're looking for your 3 months banking statements and previous address, I don't know what you call it, referrals by your previous landlord. So you can't really put in any question when you're asking for this information. But I want to hear from the advocate. So advocate, with that in mind, ubani o decide ukuthi i-tenant izoba responsible for ama-levies kule rent enikezwa ilokhuzana i-landlord. Is it still part of the body corporate, or it's the landlord that actually decides, well, we've decided as the body corporate that the levies for this month are 6,000 Rand, therefore I should charge Alicia as a new tenant an additional 4,000 Rand just to cover my levies?
No, so ordinarily, even in terms of the law, a tenant is not liable to its
for ama
levies.
Okay.
A tenant is only
but
liable...
advocate, because you'd find ukuthi in a lease mhlambe kuzothiwa rent is exclusive or include, I mean water and electricity are inclusive, but they will never say levies as well are inclusive. You never see that. I've studied quite a few of my rental agreements there. I've never seen anything about levies, but you find out when the landlords are actually going to raise rent. This is actually one of the biggest reasons, because they're saying, well, the levies have gone up, but why didn't you make me prepare for that when you were giving me the lease initially?
So when you also setting up a rent, fixing the amount as stand, you should take into account market related for the value of that property in terms of leasing. It's not dependent on levies. If I fix my rental amount as a landlord according to my levies, and I charge out of the market related, then I could be committing an unlawful act. You know, so ordinarily, and this is what I would say, the advice that I'd give to my tenant: do your homework. As Ellen has said, do your due diligence, also extending it to the extent that look at what is a fair market value for that property for a rental of, let's say, 1 bedroom or 2 bedroom in that area. So you also always need to do your due diligence, because by law, a landlord cannot charge you for levies. Suppose perhaps maybe the house is paid off and you know the situation is different, and let's say levies are 3,000 Rand, but the market related is 7,000 Rand. If the market is 7,000 Rand, then the landlord is making their profit. They can use that 7,000 Rand towards levies or towards whatever that they want to. It's a different situation. But I mean, to try and
make the tenant responsible for
what they are ordinarily not responsible for. And also, for example, rates and taxes. If I am paying directly to the municipality and I receive, and there's no body corporate, I should only be paying for what I use, which is water, electricity, sewage costs.
All right, hold it there, advocate, because I really need to ukuthi ngiphuthume Mbukeli ezitolo. We're going to take another quick ad break. Don't go anywhere. We're back shortly after that. Welcome back to Yilungelo, Lakho. We're still coming to you live, like Mamba Pambili, SABC 1 Mzansi for sure. 011-714-0671. Alternatively, 011-714-0672. Ngasithumela WhatsApp 060-844-9857. I am still joined in studio by Advocate Emmanuel Masombuka, Mr. Keith Bateman, as well as Ellen Levy. Sikhuluma la Mbukeli ngokuthi mangabe wena unenkinga between your landlord or wena we landlord, but uthola ukuthi ilokhuzana ibody corporate sicimele amanzi or basic services efana nogesi lapho uhlala khona, iziphi inyathelo ongayithatha ukuthi ulungise lokho? Let's go to the lines now. Sithathe uBhuti Malibonga all the way from Gqeberha. Bhuti Malibonga, inkosi tata for staying on the line. Sakwamukela ohlelweni, umbuzo noma umbona?
Mora sisaleshi unjani?
Ndiphilile tata, unjani?
Siyaphila nathi your topic is interesting.
Bathini?
And rent a back room ne?
Room okanye urentisa i-back room?
Yes, ndiyarenta i-back room. Now ke ngoku kwenzeke konakala ibox yombane.
Okay.
Ithi i-landlord mandifune umuntu ayilungise.
Okay.
Ndifune umuntu ayilungise ndimbhatale. At the end of the day now kakufanele ndibhatele irent kufika idate yerent athi ufuna imali yakhe yena yonke iphelele kodwa imali lena akayikhawunti lena ndiye ndayibhatala for umuntu ozile wazolungisa umbane.
Oh, okay. And then xa umbuza tata uMalibonga uthini yena?
Andiva.
If umkhumbuza uba nguwe obhatelela umuntu obezolungisa ugesi, uthini ulandlord?
Yena kwakhe icala akekho apho out of town. Uthi akekho lapho kuba ke ndisilapha ke ka une problem umfonela umxelele. Now ke ngoku ndilungise ibox yombane now yena at the month end now ufuna imali yakhe iphelele.
Okay. All right. So ke ngoku niphi tata xa usithi ufuna la mali yalomuntu ozile wazokulungisela ibox yambane uthini ulandlord?
Ulandlord ke ulungise yena uthi ufuna imali yakhe iphelele and then akayikhawunti ngokule umuntu walungisa umbane.
Okay, tata Malibonga. Do you have ilease esayiniwe nalo landlord wakho?
No, zange sign it, so take face to face.
Okay, it was a gentleman's agreement. Okay, tata siyabulele va. Nizokubuzela la. Put Malibonga, put Emmanuel. This is exactly, advocate, that we're speaking about. So gentleman has a landlord. He's renting a back room, and he phoned the landlord. He doesn't stay on the premises. He phones the landlord, tells him, listen, my is it an electrical box or something that needed to be repaired? The landlord is like, well, get somebody to come and fix it. And then he gets somebody to come and fix it because obviously he's staying in this unit. And then at the end of the month, the landlord is like, well, I want my rent in full. And he does not take into account that the tenant has already paid for the repairs that were done in the unit. So he wants to know what are some of his rights. Alan, very quickly.
Difficult question, Malibonga. That's why we encourage all tenants out there.
Oh, by the way, they've got a verbal agreement as a lease.
A verbal agreement. We encourage all tenants to put pen to paper, get a signed written lease agreement where an issue like this can be properly ventilated and put in ink. In this case, there's no written agreement. There's a verbal agreement, but in all likelihood, a term like this wasn't discussed. So in these cases, we have to resort to the common law. That's South Africa's general body of what we call inherited law. And we have to resort to the law reports to look if judges have ever considered this issue. So overall, the general principle is that when a landlord rents a property, they have to make sure that the property is in a fit and habitable state. And I would argue for Malibonga that the property is not in a fit and habitable state if the electrical box is not working. On the contrary, it's dangerous to live in.
Okay.
And I would argue that this expense is the landlord's responsibility, and that was an implied term of the lease agreement. And if the landlord won't capitulate, I would take the landlord to the Rental Housing Tribunal for an order that amount that Malibonge has spent on the electrician can be deducted from his rental.
Oh, okay. So izosebenza kanjani ke leyo advocate mefuna ukuza kunina uMalibongo?
So ordinarily what he would do, he should do, he must approach his local tribunal.
Okay.
His own, every municipality has, well, majority of municipality in terms of the act should have an authority that deals with tribunal issues. So he should approach there, he'll be met with a case manager. The case manager will then open up a file for him. And then once the file is opened, and then the matter will be referred to mediation to try and resolve it between landlord and tenant.
And then is he paying rent? Is he continuing to pay rent during this time while
He needs to pay rent.
Okay. So just to reiterate that, advocate, each tenant has a right ukuthi ayobika unfair practice by the landlord, by the respective landlords kwi housing tribunal, particularly laba barentayo.
Yes, no.
Okay.
Yeah. Well, and simply put, the simple answer is this. Two wrongs don't make no right.
Absolutely, yeah.
Because he must continue complying with his obligations.
Just like he paid for the fixing of the...
And he should not have even paid for that because the law is clear. The landlord must provide electricity and water and must be undisturbed. To the extent that is not provided, he can approach the tribunal for an urgent order. The practice in Gauteng is that we treat those type of cases relating to rent and electricity as urgent matters.
Yeah.
And they are also urgent depending on how quick you approach a tribunal.
Okay.
You can't sit for 2 months without electricity and water.
But we're a gentleman's agreement. Hold on, advocate. I want to quickly go to the lines again. See where here in Johannesburg. Thank you so much for staying on the line. A very good afternoon to Singakusiza Njani namhlanje.
Hello, Alicia.
Ngiyaphila sisu njani?
Ngiyaphila, khuluma noSiwe in Joburg.
Yebo Siwe.
Okay, what happened in 2023 in May? Masibuyela endlini in the afternoon, sathola ukuthi room seyikhiyiwe, right?
Okay.
Then sihlala ebedroom. We didn't have a written agreement, but we spoke, and then sesihlale lapha like for 5 years, right?
Okay.
So mangibuza ukuthi okay, kwenzekele kanjani ukuthi sikhiyeleke ngaphandle? That night we had to go and squat for the whole month. The approach tribunal ukuthi basincede ukuthi sibayezivulela sikhiphe impahla iseza ukuthi akasafuni masitende laphaya, but basobela umasitende wathi akasafuni laphayana benzena benzanga lutho, and then okay baphi notice ke bazomova kahle. Ukudla kwami kwamoshakala lapha Alicia, and then they clothes we were just wearing whatever we find, like my family members that for the whole month that we had to look, and the tribunal that has fully an alternative accommodation. You can't like look for an alternative accommodation in a short notice, but we had to struggle. We found another accommodation in Joburg. So one time because you have been in no room, and so I think no longer at the language okay, there is proper structures like a flat or whatever. That's why I'm currently saying that the tribunal, they don't help. I don't want to lie. We went there like 3-4 times there. We were accompanied by Amapoyisa to go there and asking landlord to not willing, but it didn't work.
Imasiwe uze nithola irumi lokhiwe sisibekwenze njani, because did you go to work one morning
because when we tried to find out what happened to us, were we in a problem? The landlord didn't explain anything, which is a problem.
Okay, but enlokhela iroom nje nempahla zenu ila ngaphakathi, yet you had to go look for alternative accommodation.
Impahla zethu bezingaphakathi, besikhiyeleke ngaphakathi. And then we had to squat for the whole month. And then I had to call me personally. Let me just beg him. Let's keep him together. Then he sent somebody, and those things that must move out here. the unorganized, the food was messed up, everything was in a mess. I don't want to lie, yeah.
Okay, sisiwe ngiyabonga sithando sami ngicela ulalele lapho kumabonakude wakho nesizozama ukuthi sizobona ukuthi sizokusiza kanjani bukeli. We need to take the ad break. I don't know if it's the final ad break. I'm hoping it's not. My director says it is the final ad break. We're coming back shortly after this. Don't go anywhere. Final segment sisaxoxa ngendaba eserious lana ukuthi uma wena unomuzi or uhlala endaweni, whether it's a back room, estate or ilokhuzana nje indlu ohlala kuyona, uthola ukuthi unomastende, uthola umastende akakhokhanga ama rates nama levies, wena ususele nendaba, usucimela ugesi, ucimelwe amanzi. My gentlemen today, Advocate Emmanuel Masombuka, Mr. Keith Bateman, as well as Mr. Alan Levy. So gentlemen, you heard there, but Advocate, I think this was being pointed directly at you because she says she did approach the tribunal multiple times, and she said emphatically on air the tribunal could not assist.
Yeah, so I think I'd need to understand what the details of those cases are, because sometimes tenants get frustrated in terms of the effectiveness of our orders and non-compliance, because you may well find that she approached the tribunal, it was dealt with on an urgent basis, a ruling was an issue.
Yes.
Now, the problem became with enforcing that ruling. And because we usually find a lot of this, where we issue out rulings, and tenants beyond our rulings have trouble enforcing those rulings. We have internally within Gauteng a dispensation where we issue out an enforcement letter to say comply within X amount of days, because also just to emphasize that our rulings are tantamount to an order of court in terms of Section 13 of the Rental Housing Act. So if you don't comply with that, even I think Section 16 is clear, you may be guilty of committing you may be guilty of contempt,
basically,
you know, and you may be imprisoned. So I think what she should do, if there is a ruling, she should go institute contempt proceedings.
Okay.
Issue contempt proceedings upon which she can either get the former landlord or the landlord to comply, or alternatively to be imprisoned.
Okay.
So that's the seriousness. And I think members of the public need to understand the status of a tribunal ruling. If you don't comply, you can end up in jail. And they should approach the members of SABC to facilitate that, or they can approach legal aid if they can't afford private attorneys for them to enforce that. You may well find that it's just an issue of enforcement, but it's something different. All right. It's a case that I'd actually want to investigate further. No problem.
Yeah. So see, we're going to give you details to Advocate Lana ezobona ukuthi uzokusiza kanjani as yena evela lapha kwi tribunal. So Keith, very quick responses. We've got very little time to go. Can a body corporate write off any levy arrears?
In terms of court judgments, unfortunately not. It needs a unanimous decision of the whole body corporate to write off debts. It's actually quite constraining, because sometimes you have situations where the body corporate would rather take less money but get money than the holdout for this pie in the sky money that's not coming.
But is that what then leads to where the body corporate, we've heard, then tends to sell the property in order to recoup all those lost levies? Does that happen? It
does. It's a very long process. Yeah. So what the better mechanism for the body...
But where does that put the bank then, where I bought the property from, Keith?
So they protect it, and what most people do is they pay the bank. Yeah. Because if you don't pay the bank, they're on you like a rash, and they report you, your credit score gets affected. But most bodies corporate don't actually inform TransUnion and these places. So the body corporate is often last on the queue to be paid. Yeah. But I want to quickly explore one other thing. There's a very nice mechanism in CSOS regulations that a body corporate can go to CSOS and get an order that a paying tenant pays the rent to the body corporate instead of to the owner.
To the owner, nice.
Yes, so for the naughty owner, there's a very, very good mechanism, an effective mechanism at CSOS. Okay. And the tenant gets notice. There's a very clear part of the order that says by paying the body corporate, his debt is just discharged to the landlord, and it works.
But then who do I have a lease with then? Like, I've got 3 more months or 3 years that is still left on this, and I'm already going through the body corporate. I'm shunning my landlord.
No, that stays in place. It stays in place. All that happens is that the CSOS order intervenes and says, please don't pay your rental to this naughty owner. Please pay it to this body corporate that needs the money.
Okay, and then I keep my services going.
Keep everything going, nothing changes.
All right, a very quick one in closing. Alan, your advice to tenants that are under landlords that might not be paying and not very forthcoming with certain information that I need as a tenant in terms of what you are in arrears of.
So the message to tenants out there watching today is open your eyes. Don't be afraid to stand up for your rights. Insist that your lease agreement be reduced to writing.
All right.
Insist that you be kept up to date from the landlord with his levy statement.
All right.
And yeah, keep your eyes open.
All right, gentlemen, gee whiz, that is Advocate Emmanuel Masumbuga from the Rental Housing Tribunal, alongside Mr. Keith Batesman there from Bluegrass Community Scheme Managers, as well as Attorney Ellen Levy there, giving us some valuable advice as well as information. Mbugeli, thank you so much, Keith, for that point. I'm sure a lot of people are actually going to be calling some of these body corporates and saying, we don't want to deal with this landlord. They've been very naughty. Mbugeli, from myself and the rest of the team, as well as my guests, thank you so much for participating in our show today. We're back next week with another live consumer affairs discussion. From all of us here, Salegal.